Hello, everybody. I guess you've all had enough time to get into the room, and hopefully everyone has downloaded the PowerPoint and we're ready to go for our webinar for Interpreting in Domestic Violence Matters. Many of you have already sent me sign-in sheets. I do not need to sign in sheets unless you are in a group of people watching on one computer. At the end of this webinar, when you close out of the webinar, a survey will populate, not just for a satisfaction survey, but also for you to provide your CEU information. That way, all of the information is sent to me electronically, and we'll know it is accurate. Also, captioning and interpreters are provided. The streaming window opens automatically. There is the tab for the audio and video on the far right. Click on the bottom corner and a menu will drop down. Click Attach Panel. Then you can resize the video box. To open the captioning, click on the captioning icon on the toolbar. Windows can be closed or sized to create your personal viewing environment. The chat window can also be made bigger by pulling it out. Click on the icon box in the upper right-hand corner of the chat box to access the menu and make the chat font bigger. If you have technical issues, use the chat function and a member of the clearinghouse staff will aid. Questions for the presenter will be in the chat function, and she will hold times for questions and answer time throughout the webinar. Please write down your questions and wait for Carla to ask for them. Then you may type them in the chat box. And I didn't introduce myself before. I am Carrie White. And if you have any issues or questions about CEUs or future webinars, please email me. Now I'd like to turn it over to Carla Mathers. Thank you, Carla.
Thank you, Carrie. Thanks, everyone, for your indulgence as we get started. I can tell that people are continuing to join. So as long as I can keep seeing them pop up in my corner, I'm going to repeat that in the chat box there is a link to the PowerPoint because the PowerPoint is not working on this particular webinar. So you need to download it and open it, and we'll go through the PowerPoint and I'll tell us when we're going to need to turn the pages. Again, I stand in awe of technology and people like Jesse who understand how this works. But anytime you get 177 interpreters together, there's got to be just a little bit of drama. So that's ours, no more. I want to thank again the Murray Center and the University of Northern Colorado for sponsoring these 5 series this summer. In particular, Jesse Zhu, Carrie White, Anna Witter-Merrithew, Lilani Johnson, and our interpreters today, Kirk and Darlene. So this is the 4th webinar in a series of 5, and we're focusing on interpreting in domestic violence matters. I do, as I have each seminar, want to put my disclaimer in and my apologies to my deaf colleagues, because in the legal interpreting field, we try to present using our shared language, and because of the technology we're unable to do that with this series, but the center is working on a different approach so that we can all be using the same language. I have another disclaimer, this one about legal advice. The content in domestic violence matters is strongly dependent upon the state in which you are located. And so no part of this discussion can be relied upon as legal advice, nor is any attorney-client relationship created by virtue of this discussion. That part's to protect me. And with that, I want to talk generally about domestic violence first and some of the policies and the reasons why so many states have taken the kind of extreme statutory action that they've taken to protect victims of domestic violence. I also will tend to say things like victims, and I know that there are terms that are preferred in the domestic violence community that might be different, such as survivors or complaining witnesses is what we use in the legal arena. I also tend to talk about generally domestic violence being male to female, but as we all know, it can be, it knows no gender, and we'll talk about that a little bit more. But so I beg your indulgence if I'm using she and he and if it offends in any manner. Domestic violence is serious, and it can be life-threatening, and the research shows that more women tend to be killed or seriously injured by intimate partners than by any other cause. People going through divorces, maybe that came about as a result of domestic violence, they have this misconception that once the parties separate in anticipation of the divorce, that the chances of domestic violence go away, and in fact they escalate. So we often see domestic violence issues in other family law matters, which is why we touched on it last time, but we'll look at it more carefully tonight. I'm going on to the second slide entitled Domestic Violence. I'm going to try to move the screen, but it'll probably go white. Look at that. So we have the second slide up, and you also have your PowerPoint. It's hard to really know the exact numbers of domestic violence and sexual assault that goes on in the United States, but people who study it say that between 2 to 4 million women are battered annually by intimate partners. It's hard to know how many men are battered, but we know they are. It's hard to estimate also the number of deaf people battered by intimate partners. But DVSA, which is the acronym for domestic violence, sexual assault, affects all socioeconomic classes and discriminates against no one. We're very fortunate in the deaf community to have a national network of DVSA advocates that was organized years ago by Abused Deaf Women's Advocacy Services. I always call it ADWA, so hard to remember what it stands for. And we'll talk a little bit more about that later. But some of what they have said about the numbers within the deaf community, from the Deaf Hope website, they say that they did an 8-year survey of college students at RIT, and that it indicated that deaf and hard of hearing people are 1.5 more times likely to be the victims of relationship violence, and that included sexual harassment, sexual assault, and psychological and physical abuse. Some people have suggested, in particular MHIT, which is the Mental Health Interpreter Training Program, that it may be more of a problem in the deaf community because it's very difficult. It's easier to get isolated, and it's difficult to leave an abusive relationship and then to go out into the deaf community and interact with community members after you leave it. So interpreters see a lot in legal settings as well as medical and therapeutic settings, and it can cause a vicarious trauma. So self-care is really important for interpreters who are going to be working in this setting. There's a quote that I read that I liked, and it said, the interpreters hold the key to the woman's voice, to her opportunity in obtaining the permanent restraining order, and to her probability of keeping her children. Many states have made it a priority public policy to protect victims of domestic violence. In Maryland, our General Assembly set forth our policy as, because of an increasing number of victims of domestic violence are forced to leave their homes to ensure their life, safety, and welfare, and that victims of domestic violence and their children are often economically dependent upon the abuser, and they have no other place to live outside of the household. And in the past, domestic violence has been ignored, and therefore there is a lack of services, counseling, and quality emergency public or private housing to provide a place to live. As a result, the Maryland General Assembly enacted our statutes, providing protections to victims of domestic violence. That public policy favors the initial protection of the petitioner, the person seeking protection. So the burden for getting an initial protective order is very, very low, and I'll go through what those burdens are. In Maryland also, public policy requires that you can get a protective order 24 hours a day, 7 days a week. And that can be issued without the other party being there, which is what we call an ex parte order. Then, once notice is given to the respondent, a full evidentiary hearing is held to determine at a much higher burden whether or not there's a likelihood that domestic violence didn't occur. So in Maryland, you can file what we call a DVPO, Domestic Violence Protective Order, in any court in the county, in the state. You can file it in any clerk's office in the state. And if the clerk's office is closed, then we have commissioners available 24/7. So every state is going to have a different particular procedure, but they all have some similarities. We'll go through the similarities in the next couple of slides. I'm going on to the next slide, which is blank. So I'll go back and see if I leave it there, maybe it'll upload. In your PowerPoint, it's called Understanding DV Procedure, and then there are 2 bullets. One says Civil System, and one says Criminal System. So, in domestic violence situations, you can have a criminal and a civil matter going on simultaneously, and they can be the result of the same violent act. So, a person who's experienced domestic violence has 2 different remedies, and sometimes more. In a civil DV action, the person's asking the court for protection. You're not asking, the person is not asking the court to send the person to jail, or the respondent to jail. But if the abuser violates a civil court order, he may be sent to jail for that violation. So in a civil case, it's the victim bringing the case against the abuser. So in most circumstances, that person also has the right to withdraw the case or drop it. So the major difference between the civil system, domestic violence, and the criminal system, domestic violence, is who takes the case to court and the reason for the case. So in the criminal law system, obviously criminal law handles all violations of the law, such as harassment, assault, murder, theft. A criminal complaint is filed, and the abuser is charged with crime. So in a criminal case, it's the prosecutor, and in some places that person's called a district attorney or a state's attorney, but that's the person who has control over the case. And so it's not up to the victim to determine whether the case goes, so they can't usually just change their mind and drop the case. So sometimes it's possible, even in a criminal setting, depending on the state, that the victim doesn't want to press charges, and the prosecutor might drop the case. You might also see issues related to asserting a privilege, a marital communications privilege. And again, that is heavily dependent upon your state law. You can't be forced, under that privilege, you can't be forced to testify against your spouse. So if a victim of domestic violence changed her mind and recanted her story or didn't want to testify, the state couldn't force her. What we did in Maryland was in Maryland, our statute says you can assert that privilege once, and then thereafter the state can force you to testify against your spouse. And that's, again, part of the public policy against or in favor of supporting or protecting victims of abuse. So we'll come back a little bit later to some of the overlay between domestic violence and other types of matters. I'm going to go see if I can get to the third slide, which is what we just did, understanding civil procedures, what you ought to see on your screen. And we're done with it. So we'll go on, hopefully, to the fourth slide. All right, we'll leave it blank and see if it pops up. This slide is the fourth slide, and it's called Definitions. It says domestic violence, sexual assault, relationship rape, stalking, cyber stalking, protective orders, and domestic violence courts. So domestic violence, in layman's terms, is assaultive behavior involving adults in an intimate, sexual, and usually cohabitating relationship. A more legal definition, taking from the Maryland statute, a victim of domestic violence means a person who has received deliberate, severe, and demonstrable physical injury, or is in fear of imminent, deliberate, severe, and demonstrable physical injury from a current or former spouse or a current or former cohabitant. It's often a pattern of abuse, a pattern of physical assault, threats, coercive behaviors, primarily used to maintain control over the other person. Abusive behavior can be ongoing verbal, emotional, sexual, physical, psychological, and economic abuse. So as I go through this list of items that the National Coalition Against Domestic Violence, which is estimated that up to 30% of women will experience it during their lifetime, as I go through this list of items, think about, as an interpreter, the implications of the sign choices, particularly if you have no context, if they're read off in a list, as I'm getting ready to do. And think also about the time necessary to create or convey the concept. So examples of abusive techniques include hitting, kicking, and punching. Preventing access to or knowledge of family finances. Threatening to take custody of children or threatening to take children away. Harming children as a punishment to the spouse or partner. Destroying property, harming pets, berating in front of children or family or friends, threatening violence, monitoring where your partner goes and who she sees, or restricting access to family and friends. Accusing her of infidelity, or forcing her to perform sexual acts or behaviors she does not want to do. So that list, in just looking at that list, many of those are also crimes. Sexual assault or rape is any form of non-consensual sexual activity encompassing all unwanted acts from intimidation to penetration. It's a form of violence used to humiliate and intimidate, control, or instill fear in another person, including forced and unwanted sexual activity, rape, incest, and sexual abuse. You think about the common law definition of assault. Assault doesn't, at common law, didn't, in the olden days, is what we mean when we say at common law, didn't necessarily involve a touching, but it always included instilling fear. So this is using sex or the threat of sex or force to make another person be afraid. So the legal definitions are going to vary by state, but it can be, sexual assault can be verbal, visual, anything that forces unwanted sexual contact or attention. Examples might be voyeurism, when someone watches private sexual acts, exhibitionism, which is when someone exposes himself or herself in public, incest, which is sex between family members, and sexual harassment. So sexual assault is a crime as well as a basis for a domestic violence protective order in all 50 states, although the laws vary among the jurisdictions. Relationship rape. It's date rape, you might have heard it called. Essentially, according to some of the research I did, that it's not uncommon, and that at least 7.7 women will be sexually assaulted. I think it's like that one, excuse me, 77% of women will be sexually assaulted by an intimate partner. And that's not assaulted and then it's reported and then it goes to court, because it happens frequently, but people are afraid to talk about it, so it's very underreported. Sometimes people are sexually assaulted by strangers, but more often they're assaulted by someone they know. So they're on a date, or it's a friend or a relative or an acquaintance, or even a longtime partner or spouse. So marital rape is in fact illegal in all 50 states and the District of Columbia, but it might be treated differently than non-spousal rape in some ways. So you might have a shorter period of time to report the act than if you were not married to the person. You also might have to, in some jurisdictions, show that more force was used than if you had not been married to that person. Another thing that's protected by domestic violence laws is stalking and cyber stalking. And again, it depends on your state, but stalking generally involves repeated acts that would cause a reasonable person to fear for his or her safety. And in some places, it could also include a family member's safety. So protective orders are the remedies for domestic violence. And depending on where you live, they could be called a restraining order, an order of protection, a civil protection order or protective order, or an ex parte, temporary, or permanent restraining order. So each state's going to have a law that explains who's eligible for relief under these statutes and what kinds of acts are protected. And sometimes domestic violence cases are centered in specialized courts called domestic violence courts. And they handle all aspects of the domestic violence case, including the restraining order, any violations of the order, related family law matters, and sometimes purely criminal actions, such as the assault charges that might stem from a DV case. And obviously there's a benefit there, because you've got specialization of the professionals. Judges sit on these benches and they become experts at working with victims and perpetrators, as well as with the local laws and the available resources. The attorneys who practice in those courts, both prosecutors and defense attorneys, handle a case vertically, meaning that the attorney deals with the case from A to Z, from start to finish. I think it would be an interesting concept to talk about applying the same verticality to interpreters. So if there were one domestic violence court, one court interpreter would work with the litigant, and I'm talking about a proceedings interpreter. They'd work all phases of that litigant's proceedings, all phases of the civil cases, the domestic violence matters, and the criminal cases. I think that the litigant might have more trust in the interpreter, become more forthcoming. Certainly the preparation issues would be less challenging because you've seen the story a number of different times, as has the judge, as has the attorneys. Consequently, I think there would be simply more accurate information that the court can rely on. All right, for those of you who joined us late, and keeps getting announced, the PowerPoint the PowerPoint sometimes works here, and otherwise you can download it, and then we can go through it, turning pages as we go. The link is in the chat column at 5:18 p.m. if you want to go up and download it. And what I'm going to do, we're going to go more thoroughly through some of the procedures for protective orders. But I'd like to stop now just in case anyone needs clarification, or if there are any questions about some of the definitions and the general public policy that we've gone through. I'm looking for questions, and I see that some people are still experiencing technical difficulties. And we do have a question. I'm not sure I understand relationship rape. And I'm happy to, yes. Relationship rape is when you are forced to have unwanted sexual contact with someone who is not a stranger. Right? So a boyfriend, it's also called date rape, and it's also called acquaintance rape. Right? So it's someone that you know, or it's not a complete stranger. And I think that goes back to people feeling like you can't be raped if you're in a relationship. But if the definition of rape is unwanted sexual contact, then it doesn't matter if it's your husband. And yes, marital rape is against the law in all 50 states. So you can definitely be prosecuted for raping your wife. I want to go up. I just want to review cyberstalking and stalking. Cyberstalking is when you're harassing someone and they are frightened, and you're doing it via electronic mail or the internet or using a computer somehow. Stalking is typically following someone, physically following them. There are other instances of abuse that can be protected in a domestic violence setting other than these, and we'll go through some of them. All right, so I'm going back up to questions. Give me a moment to read some of these. There's a question about whether a spouse can be served with a subpoena to testify for the state attorney's criminal charge against his or her spouse. If the state in which that occurs has a privilege protecting spouses from being called to testify, then she can be called, she can be subpoenaed, she can be served, she can go, and then she would assert the privilege and refuse to testify, but you still have to go. Right. Just depends on the state as to whether or not the spouse has to testify. Okay, so I saw some comments. I'm not entirely sure they were questions. Denise has asked, how do you deal with the dicey situation of older children who have witnessed the abuse? Suppose you have a 10 or a 12 to 13-year-old, can they be called to testify? Yes, they can be called to testify. If it's a criminal case, then they absolutely can be called, and the defendant has a right to confront the witnesses against him. So the children would either have to testify in person, or sometimes they allow the children to testify by closed circuit TV, or outside of the presence, they might clear the courtroom to make it a little bit more private. In a domestic violence matter, or certainly in a family law matter, oftentimes the children are interviewed by the judge either alone or by the judge and the attorneys, but not with the parents. I don't think there's a general consensus. As long as the child is competent, which is why when you're interpreting, you hear the questions, do you know the difference between a truth and a lie? As long as the child is competent, then they can be called. It just may not be in front of the public, but if it's in a criminal case and the child is testifying to a criminal activity, then the defendant has the right to see that testimony. We have a question from Stefanian Saraf. If you're married, would it still be called relationship rape, or what is the correct term as it relates to jargon? The correct term is marital rape. And as I said, it's a crime in all 50 states and the District of Columbia. It's just what you have to prove varies. Can we have a copy of the legal definitions that were reviewed? I couldn't keep up with my note-taking. The absolute best thing that you should do, that was from Summer Carlson, the best thing that you can do is to go on your state court website so that you can pull up your definitions. And we're going to talk about preparing as an interpreter, but one of the things that you can make much use of is the court's website, because it'll have a number of the forms that you want to review and to research. It'll also have your state law. And I'm probably getting ahead of myself, but because we have the question, except I just lost my response. Hate it when that happens. Well, since I thought I was getting ahead of myself, it'll probably show up later in the presentation. Okay. I have a question from Tracy Heffernan. Do you have a percentage of people who are hurt or killed after they have a restraining order put on the person that is injuring them? No, I don't, but I know that there are going to be those statistics available. And certainly we've had high-profile issues here in Maryland where a judge here in actually the court in my district, 2 blocks from my house, refused to give a woman a protective order, and it wasn't very long after that, but a gentleman the perpetrator threw acid in her face, and she's alive, and she's burned throughout her face, her shoulders, her chest with this terrible, terrible acid. And she now works nationally in the area of educating judges on domestic violence and partner violence. So there's a website I'm going to tell you that I looked, and I'm going to tell you because it relates to asking for the legal definition. It's Women's Law, all one word, womenslaw.org. And there's a tab in there that you can look up your own state law. And so the definitions that I gave you when I cited Maryland will be there under your specific state. Okay, so Amber asks, is the statute of limitations longer for marital rape than relationship rape? No, it is shorter. It is shorter. Is at least one of the things that can be done, and sometimes you have to show that there was more force involved. And that makes sense, right? You don't want, a husband and a wife who fight and then reconcile, and then sometime later there's a divorce, and then sometimes later there's allegations of rape. So if it really is rape, then it needs to be reported as if it were stranger rape, but in a little bit shorter period of time. All right. So we're going to go to the next slide, which says define person eligible for release and abuse. This is particularly Maryland, but you're going to see many of the similar concepts in your state statutes. So in Maryland, we call the quote-unquote victim a person eligible for relief. That means they can file a petition for protection from the domestic violence. And they're eligible if they're filing against a current or former, if they are a current or former spouse, or if they are a cohabitant, or if they're filing against a person related by blood, marriage, or adoption. If the person they're filing against is a parent, if the person filing, is a parent, step-parent, child, or stepchild of the respondent. This is a little bit confusing. Essentially, you're a family member, and at some time in the past 1 year, you've lived with the abuser for at least 90 days. It doesn't have to be the most recent 90 days, but at some 90-day period within the last year, and you are the abuser's parent, step-parent, child, or stepchild. Or what we call a vulnerable adult, and that just means an older person, and that's the soft term that Maryland chose to use. Or you're a person who has a child in common. You have a child with the person you're alleging has abused you. So that's called a person eligible for release. And then Maryland defines abuse as one of the following acts: an act that either causes serious bodily harm or places the petitioner in fear of serious bodily harm. Again, thinking about how we sign these, it can be really challenging. We'll come back to that. Assault in any degree, and today, at least the Maryland assault statute includes what we typically think of as battery. So our assault can be either putting someone in fear of serious bodily harm or putting someone in fear and actually touching them without consent. It could also be rape, a sexual offense, or attempted rape, or attempted sexual offense. Abuse can be false imprisonment. Abuse can be abuse of a child, or abuse of a vulnerable adult. So the current spouse might file a petition for relief against her husband for false imprisonment. Those are the items that give you what we call standing to file a complaint. So the next slide is slide 6. It's called provisions, and essentially what it is what's going to be in the protective order. And the vocabulary, this is what the slide says. Vocabulary is dependent upon the state. Then there are cease abuse provisions. And I'll go through each of these. Stay away provisions. No contact provisions. Restitution provisions. Relinquish firearm provisions. Custody, visitation, and support provisions. And then some points about enforcement. So obviously a cease abuse means the protective cease abuse provision means the protective order says that the respondent has to stop abusing the petitioner. Stop whatever hurting or threatening the person's doing. The stay away provision can include staying away from the petitioner, from their home, their workplace, or their school. The no contact provisions include all contact. Could be telephone, VP, text messages, notes, mail. You remember that thing called a fax? Email, or third parties. So you can't have your buddy contact the person as a protective order. Even things like delivering flowers or gifts is prohibited under these no contact provisions. There can be restitution provisions, meaning you may have had medical costs or property damage. So the court can order the respondent to pay those. The relinquish firearms provision is one we have in Maryland. And that's an order requiring the respondent to turn over any guns or rifles or ammunition. They might also require them to go to a batterers treatment program. Or an alcohol or drug abuse counseling or treatment program. The custody, visitation, and support provisions, that's the overlap between family law that we saw. So the court can order temporary custody. They can order visitation, and if it's not in the best interest of the child, they can order it supervised. And support orders. So once you have the order, oftentimes we tell clients that they should take it with them everywhere they go, because you may never know where you're going to run into this person, and may need to call the police and show them that you have a valid order. So if you have a valid order, you can get it enforced either through the police or through the court, depending on what provisions you're asking to be enforced, and sometimes both. So the police can enforce the things like stayaways. No contacts. Cease abuse provisions. And sometimes the use and possession of the home provisions and custody provisions. Oh, that's a slide or so behind, so it's coming. Those are good when you need an immediate response. You call the police. But there are other kinds, right, and if they are found to have violated the order, then it can be either a misdemeanor or a felony, depending on the state. Other violations of specific provisions are really not very easy for the police to enforce, like those requiring the person to pay child support or attend a treatment program. Those are enforced by filing a motion for contempt and explain how the order was violated. And then there's a hearing to determine whether or not the person violated the order. And then the judge determines the penalty. And the penalty can be contempt, and contempt could result either in a fine or in a period of imprisonment, or both. And you might also want to get the petitioner may also want to get the protective order modified or extended in some way upon a showing of this person having violated the order. That is that's what I wanted to say about the contents of the protective order. We're going to talk about procedure next, and then we're going to go into some of interpreting issues. So are there any questions just about who's eligible and, just about right, who's eligible and the kinds of abuse that there are. And the contents of the protective order. Someone asked whether, are we saying relief or release? And it is relief. And that means what you're asking the court to do for you. It's eligible for relief. F as in Frank. I'm asked about the definition of vulnerable adult, and it may or may not include someone with a physical disability. You have to really look at the state statute to see what it says. In Maryland, the 90 days, I think, needs to be continuous. I haven't done this in a while. And so I think Barbara Mathis, no, Adonis, you'll have to check your state statute. Chrissy asks, are there any charges for plaintiffs who did petition for a stay away or no contact yet they continued to reach out to the abuser or the defendant? That's a good question. What we often see in court is mutual protective orders. In other words, people filing against each other. And it can get really sticky because if you get a protective order and you initiate, as the petitioner, you initiate contact, then turn around and claim that the respondent violated the protective order, you can see the potential for abuse with these. So the respondent definitely, and I've seen it over and over and over, where both sides are having mutual protective orders, and they consent to them. That's one of the options. And Kirsty continues with really good questions. I think that, and the question is, what are the conditions for stay away provisions if both parties work at the same workplace, or go to the same school? I don't think that a court's going to deny someone employment or the right to get an education by telling them that they cannot go to work or cannot go to school. There would have to be some compromise reached, that they both agree that they'll share a schedule and, in other words, inform each other of their schedules and not be there at the same time. Or if they have to be there at the same time, maybe there's some third-party visitation. I'm sorry, third-party supervision. Okay. All right, so I'm going to continue on just to give you an idea, okay, of the basic procedure. And here in Maryland, we have three-part policy. There's interim relief, temporary relief, and final relief. So if you're abused on a Saturday night, you can go to a court commissioner at any police station, and you can get an order that usually lasts 3 days. We call it an interim order. And it goes into effect once the respondent is served with the paperwork, and it lasts only until a judge can hold a temporary hearing, and that's usually in a couple of days. And this was designed for that gap between Friday and Monday morning. Then we have temporary protective orders. And that's when you go to court during a normal court hour, and you file a protective order, and they issue it on the same day. It's issued ex parte, which means the abuser's not present, and there's not a full hearing. That order in Maryland lasts up to 7 days after service, although it can be extended. But the burden is still very low. It's only, you have to show reasonable grounds to believe that abuse occurred. It's much less than preponderance of the evidence or reasonable doubt or some of the other standards of proof or burdens of proof that you've heard of. So that after the temporary order, then there's a full evidentiary hearing called the final protective order hearing, and it can only be issued after both sides have had the opportunity to present full testimony at a court hearing. And although a judge, if he believes that abuse occurred, he can grant the order, or both parties can consent to the entry of a protective order. Those, at least in Maryland, last to a year and can be extended to 2 years. And finally, a final order can be permanent. And that doesn't happen often, and it usually involves if the person, the abuser, has had one or more instances of abusing the petitioner in the past and has gone to prison for those acts of violence, then and has served in prison for a period of time, then the petitioner can get a permanent order in Maryland. In a final protective order hearing, the burden is clear and convincing evidence that the abuse occurred. That's the standard of proof. And that's higher than preponderance of evidence and below reasonable doubt. Clear and convincing evidence is an in-between kind of standard of proof. All right, so I'm on the next slide. And essentially talks about procedure, but really more, this is a kind of a segue into interpreting issues. I mean, if you think about the statutory language, and if you don't have any context, it's very difficult to know how to choose the appropriate vocabulary in both languages for some of the statutory features, like refrain from further abuse or threats of abuse. I mean, what does that look like in sign? And if we can't do it well without context, I mean, how do we get the context? And you can do some measure of predicting, but again, how you prepare and how you first see the story, depending upon who you see the story from, is going to affect how you sign it. And there's always two sides to a story. And they're generally, in this kind of a context, not aligned. So the narrative is going to be framed by whether they're coming from the perspective of the petitioner or the respondent. So you hear you're to refrain from contacting, attempting to contact, or harassing eligible persons. Again, we can give examples, we can do that, but it's very difficult. It's difficult to keep them abstract if they need to be abstract, and it's difficult to use the context if you have two people looking at you who have wildly different visions of what happened. If one party is saying, I was violently assaulted and raped, and the respondent was saying, we were on a date, it was consensual, I thought she wanted it, how you would sign those two perspectives would be very different depending on who's doing the talking. So other interpreting issues. I mentioned to you the state court websites. You can get almost all of the forms to fill out to, well, I should back up. To file a domestic violence protective order, you fill out a form. You don't have to have an attorney, and many, many people don't have attorneys. But you fill out this form, and it goes through the statutory factors in your state to see if you qualify for protection. So go to your state court website. You can download the form there. You can see what kinds of items have to be established. They're great practice forms. You can research unfamiliar technology. And even if you are actually doing an intake for a domestic violence case, you can offer to do a site translation if the person needs assistance in both in filling out and in understanding the form. So I'm on the next slide. It's called peace orders. Briefly, the only thing I want to say is that in Maryland, domestic violence protective orders are for those specific categories of people that I mentioned under persons eligible for relief. But if you don't fall into that category, that's what a peace order is. It protects people who don't qualify for DVPOs. So a couple of examples might be a boyfriend or girlfriend you don't have a child in common with, or a neighbor, or a coworker, or a stranger. So we have a way to take care of, actually I think this came into effect as a result primarily to protect violence within the gay and lesbian community. But it protects people who are not married, who don't have kids in common, and that kind of thing. They also have the same process: temporary, interim, temporary, and final peace orders. So I'm on slide 10, relationship to other proceedings. Slide 10 on the PowerPoint. I already mentioned how the same conduct can form the basis of a criminal violation or charge, as well as a domestic violence matter. But certain acts also qualify as a civil cause of action. So if you've been assaulted, you could file a domestic violence case, you could press criminal charges, and you could also sue for money damages if necessary. I've also a couple of crimes that are also domestic violence, abuse, including rape, sexual offenses, stalking. In Maryland, we have misuse of telephone facilities, so that's telephone harassment. And we have misuse of electronic mail, which is cyber stalking or email harassment. And we have malicious destruction of property, among others. So people often try to use the domestic violence petition as a way to start that one-year separation that they need in Maryland to get a divorce or custody. So we often so our courts have the power to order temporary custody, child support, and visitation. Again, depending on whether visitation, supervised or not, is going to be safe for the child. They can also order family maintenance, which is a monthly amount of money different from child support that is to, like for mortgage and for food and for bills and utilities, so that the family unit can continue to live where they are. If you do have an order, a protective order is good anywhere in the United States as long as it was good in the state that you received it. And a couple of other requirements as well. I'm moving on to preparation for interpreting, because I want to stop after here, have some more discussion after this slide and as well as the next slide. So preparation for interpreting, it has 4 bullet points. It's case file, evidence, pro se parties, and linguistic choices. So in terms of the case files, when you're preparing to interpret a domestic violence matter, the extent of the file is going to depend on the nature of the case. You've already downloaded the forms in blank, and so you should expect to see those as the complaint. And you would be familiar with those as well, both because they're in blank, and then you will have either filled them out or reviewed them with the petitioner. But then you need the details. And sometimes the cases are extensive. So if there were numerous petitions filed, and then if there were temporary custody and visitation proceedings, and if it became a divorce, and if there was domestic violence that happened at visitations, case files can be kind of extensive. When they're that extensive, though, there's usually an attorney. And that attorney can refer you to the pertinent documents and the relevant history so that you can be as prepared as possible for whatever the parties with this long history are dealing with on that day. And the attorney can also give you a factual overview, which will assist, in predicting and producing equivalent messages. I'm jumping to pro se, and I'll come back to evidence. Many of the cases that I do in domestic violence courts are pro se. And pro se doesn't mean don't have a lawyer. It means you're acting as your own lawyer, and that can cause many, many problems. But in terms of preparation, what it means is you have to prepare with both of the parties as if they are lawyers. So you will be getting some of the factual details. You do a short interview with them to find out why we're here today. What are we going to be talking about? Those are conversations we don't have with deaf people when they have an attorney retained. But if they are functioning as their own attorney, then we do have those short conversations with them. And in terms of being pro se, you're going to have the same issues that hearing pro se litigants have as the deaf litigants have, and that means they don't know how to run the case. They don't know how to question each other. They don't know that they're supposed to ask questions and not give speeches, and so all of that implicates what we can expect to see when we're interpreting for them. They'll be addressing each other in court, examining each other. There will be side conversations between them that shouldn't happen, and you may be the only person who can see that they are communicating with each other when they're not supposed to be communicating with each other. The court needs to be aware of this. Going back to evidence, in a domestic violence case, evidence will obviously include testimony from the parties, but you can also anticipate that it might include medical reports of any injuries, police reports, photographs of injuries, maybe things that were destroyed, household objects that were broken, photographs of wherever the incident took place. If it was inside the house, it might be in disarray, and so photographs. Pictures of weapons, tapes of 911 calls, certified copies of relevant criminal convictions. Often abused women, or men I suppose, but they're advised to keep a journal or a diary, so those diaries might be introduced, maybe a calendar. Anything else that might help the person convince the court could be considered as evidence. In terms of linguistic choices, again, as I said, when you hear the story from the petitioner, usually first, it might affect how you prep with the other side. So you have to be really cognizant of your choices so that you don't influence the other side. If she's filed a complaint for a serious bodily harm, like I said before, a violent rape, and his perspective is that it was consensual, then you have to think about the first time you see the stories from her, you have to be very cognizant that that doesn't affect how you interact with him. Those preparation sessions should be private. If there are deaf people on both sides, then you should find a witness room or go somewhere the person can feel safe and can feel that they can prepare with you without having the person that they're filing against watch. And if there's an attorney present, obviously you'd have the attorney there with you, or an advocate, whoever happens to be with you. All right, so does anyone have any questions or comments or thoughts in regards to preparation? Liz asks, do you ever run into problems getting access to case files if the victim is a minor? I have not. I have in the past gone to the judge's secretary when I was having, actually, that was a termination of parental rights case, but that's one resource for you is to go to the judge's secretary. If you have the case number and if the defendant is an adult, then you can get the case file from the clerk's office, regardless of the age of the victim, unless there's some kind of protective order on the file, but I haven't ever seen that. You shouldn't have any problem getting it as long as you have the case number. And then if you do, you can always go to the judge through either his secretary or law clerk. Amber asks, does that include attorney-client privilege when a deaf person represents themselves? That's a good question, Amber. There is no privilege when the deaf person is functioning pro se, because he is his own client. So any conversations that they have don't need to be interpreted. Okay, so Leslie asked, any sites that help? And I'm not sure what you mean by that. All right, so I'm going to move on to the next slide, interpreting protocol. And Carrie, I need to ask a clarifying question. Do we have a little bit more time? Because I'm not sure entirely what time we started, but I know it wasn't at 6.
One of the interpreters has agreed to stay. It's up to Jesse if we can extend the time or not.
Okay, so let me know. I'll go to the supervised chat room, I guess, or let me know one way or the other. And the interpreting protocol slide has 4 bullets: appearance conflicts, visual language issues, providing resources, and advocacy. When I say appearance conflicts, I think that they may be more pronounced, meaning that as a proceedings interpreter, you need to be more careful in preparing with both sides when they arrive to the appearances of what it looks like if you're huddling with the petitioner and then the respondent walks in, how they feel, or vice versa. You just need to be hyper aware of what you look like, even if you're doing something innocuous. Right. So you do have to do that short interview, as I said, and you have to be careful that you don't get too much information, but you do want to know essentially what happened, where did it happen, and what it looked like, so that you can get an idea of how the parties talk about it. The question is, I mean, it may be that the question is, who do you go to first, him or her? But it may be that is handled by the fact that if the petitioner is deaf, you probably go to the petitioner first. Some visual language issues. You may want to suggest that between counsel tables, if there are deaf people at both tables, that screens be provided to prevent them from viewing each other if they have counsel and they are having privileged communications, if there's an attorney present. Additionally, in high-profile cases or other cases, for example, in D.C., we have deaf advocates who come to court with their clients, and they may be sitting in the audience. And you may want to suggest screens so that audience members can't see privileged communications at the table. Some courtrooms, it's not an issue. It's a natural barrier there between the audience and the well of the courtroom. You have a kind of a fence thing. So, but these are items you can suggest. So again, you want to keep the conversations at the table private, but you don't want the proceedings to be private. So if there are deaf people in the audience, they have a right they have a right to have access to justice, which means go into the court and watch. And the court has an obligation to make that accommodation. So the proceedings interpreters, who are usually focusing primarily on the deaf litigant, but you can't lose sight of the fact that the court has an obligation to provide accommodations to deaf audience members, and you are that accommodation. So sometimes what I do is have people move if they can't see me, through the court, of course. And the court's generally pretty flexible about that. They'd rather move things around a bit than hire 2 more interpreters to come in and take care of the audience. Right. So again, you need to be ultra cognizant of what you're doing and how you look. I'm going to give you a really sad example. And it happened a number of years ago in a domestic violence case. And there were 2 court interpreters, and each party had counsel, and each party had their own table interpreters. And when the table interpreters interpreted the conversation at the table, the interpreters were sitting in, the court interpreters, the PIs, were sitting in swivel chairs in front of the witness. So they would swivel and physically turn their back to the conversation that was going on at the table out of respect. They knew it was privileged. And then during one of the witnesses' testimony, they were talking about this event where the petitioner had seen a conversation about some children they had in common, and the petitioner got very upset. So that was the testimony. This conversation had been overseen. When all of the testimony and all of the witnesses were finished, the judge was entering his finding of facts at the end of the case. The proof portion of the case was over, and it was simply reading his decision. And what he did was he used the proceedings interpreter's behavior in swiveling away from the table interpreter's interpreted conversation. He used that as evidence that one spouse had acted improperly in, quote, overseeing the kitchen or this conversation of the other spouse. He had surmised by the proceedings interpreters physically moving away from the conversation that there was a rule in deaf culture that you're not supposed to look at other signed conversations. And he held it against one of the spouses. So I say that to say he didn't know about the cultural rule of free eyes, and if you have a conversation in public in sign language, you don't have an expectation of privacy in that conversation. Yet he used this behavior of the interpreter, conduct of the interpreters, to hurt the other, to bolster his decision against one of the parties. So at that point, he made his ruling. The interpreters couldn't stop and say, "No, judge, you got it wrong." But the moral of the story is you have to beware of your behavior, make it minimal so that you don't impact the proceedings. A couple other visual issues. If you have a case where there are a lot of deaf witnesses, keep in mind that there's the rule on witnesses, and so most of them many times will be waiting outside in a witness room or outside in the hallway before they can come into the courtroom and be called. They look through the windows at some court doors, ours do. We have these tall, narrow windows, and if the court interpreter sees a deaf person standing, looking into the courtroom, accessing the interpretation, then the court interpreter is the sole holder of that information and has an obligation to let the court know that the rule on witness is being violated, however unintentionally. So as a proceedings interpreter, you're a good resource for knowledge about what's in the local community. You may know of batterer intervention programs, shelters, or restraining order clinics. I think sometimes interpreters don't feel comfortable providing resources, but I do think it's appropriate, particularly if there's not an advocate present. If an advocate's present, they're already going to have those resources, and that will be for the advocate to provide. We are fortunate that we have this great network of advocacy services. There are 15, or there were 15 specific advocacy services under the umbrella of ADLAS. In 1998, ADLAS was awarded a $300,000 grant from the Department of Justice to train deaf people from 15 cities across America to replicate their model, the ADLAS model. In total, 75 deaf women received the training over 3 years. Here my notes say, take a moment to read the slide. But the cities are Austin, Denver, Minneapolis, Detroit, Flint, Boston, Burlington, Vermont, Rochester, New York, Columbus, Ohio, San Francisco, Honolulu, Salt Lake City, Philadelphia, Chicago, Des Moines, and Washington, D.C. So if those are anywhere near your area, those are the places that you can go, or you can look on their websites. The AdWatch website has a full list of them. The one in D.C. is called Dawn. There's Deaf Hope. There's Dove. There's Deaf Women Against Domestic Violence of Wisconsin. There are a variety of different names of them, and some may not still be in existence, but they are very good resources. And at least in D.C., I was fortunate to be on the board of directors of Dawn for a couple of years, and they work really hard to ensure that deaf victims of domestic violence and sexual assault have advocates with them when they go to court proceedings. Now, my next slide is our final slide, and it might come up. And while it does come up, I will check and see if there are any questions. I have a question, let's see, from Lori Kalka, and it's, when doing the restraining order site interpretation, should we have a lawyer present so we don't look like we are an expert? Yes. I can tell you, though, if a deaf woman shows up at the clerk's office at 9 o'clock on Saturday night to get a restraining order, she won't have a lawyer and she won't have an interpreter. And that's a problem, and that's probably a good area where VRI might be utilized. But if you do happen to be there, and she does have counsel, then you wouldn't want to do any site translation or any other translation without the attorney present. I see Shelley Herbold has a comment/question. She had the same problem with access to a case file when the victim or defendant is a minor. Most of the time, the lawyer would allow me to take a quick review when I arrive, or explain the case before we go in. Not much preparation. So just a couple things about that. If the victim is a minor and the defendant is an adult, and you have the case number, you don't need anybody's permission to view the case. They're public, right? So just what you do need to do is go down the day before to review the case, or an hour before. If you show up at the same day, that case file is not going to be in the clerk's office. It's going to be in the courtroom. And you can still ask the court clerk, the one in the courtroom, to see the file. Sometimes they get a little funky. The best way to do it is to get it well ahead of time. If the defendant is a minor, it depends on the state as to whether or not those are public or not. In Maryland, they are public. In other states, I'm aware that they're not. You should also have the lawyer, ask the lawyer to see their case file, if they'll allow you this quick review, and to explain the case. So there's never as much as we like, but we definitely have to take a proactive approach in getting as much information as we can. Teresa's asking, you mentioned about giving examples of being careful to sign because of different perspectives. Is it always okay to expand, or is it something we have to be careful about in court? If by expand you mean including contextualization in your interpretation, then it is okay, and you have to be careful. Just like you have to be careful about all of your interpreting, so that it's not, this is difficult, not too much, not enough, just right, kind of that much. You don't want to be suggesting answers to the witness. You want to make sure that they're able to choose from among your examples, and as well as come up with like items that are not in your list on their own. Okay. Brenda asked, thinking about pro se parties, one deaf and one hearing, would it be awkward? It would be awkward to walk up to a hearing person and ask them what happened. No? Yes, I agree. That would be awkward. I would find out who the petitioner is. I would, if that's the hearing person, I would ask to read a copy of their petition. I wouldn't ask them what happened, and I would let the deaf person know what I was doing before I did it. Likewise, if the deaf person's the petitioner, I would let the hearing person know that I was the court's interpreter and I needed to review the petition. And that's all I would tell them. And then I would ask the deaf person in private to see their petition, and if I wasn't entirely clear or if there were obvious obvious things like classifiers that I knew I was going to need, then I might ask them to show me how they talked about it. Well. Okay. I don't understand Terry White's comment, and we're right up at the last site. So let me just see if I can find any of these that I can answer really quickly. Barbara asked about whether or not the decision was appealed with the interpreters who swiveled. No, no, not on that basis. I don't know what happened with that after it happened. All right, you can see the final slide is our next step, and the next step is our final webinar on September 21st, which I think is a Saturday. No, that's August. I'm checking the date. It is in fact Saturday, and it will be 1 to 2:30 Eastern Standard Time, and we'll be talking about interpreting for depositions. This slide also gives you access to the archived sessions and how to get CEUs. And I know that Carolyn is going to talk to you about that right now. And so I'd just like to say thank you for your time. I apologize for the technical difficulties, but glad it was the fourth one and not the first one that happened on, because we know we can do it right. So thank you very much, and I'll give it back to you, Carolyn.
First, before you guys start closing out, when you close out, a survey should populate. It is a satisfaction survey, but this survey also will ask you for your CEU information. If the survey does not populate, please email me at Carolyn, CAROLYN, .white, WHITE, @UNCO.edu. Please fill out the survey if you're watching this individually. If you have several people watching the group, then please fill out the sign-in sheet that was attached to the webinar link, and you can email that to me, fax it, or scan it, snail mail it, whatever you need to do, and I will take care of your CEUs. I want to thank Carla for all these amazing webinars she's given us, and I'd like to thank Kirk and Darlene, our interpreters, and our captionist Sharon, and of course Jessie and her amazing clearinghouse team. We wouldn't be here without them. There is a listserv associated with these webinars. I will send out an email tomorrow giving the information for that. The listservs are not for CEUs this time, but they are an excellent way for you to contact Carla and ask some questions and interact with your peers. If you have any questions about upcoming webinars, you may visit the Marie website, or you may contact me at my email address that I just sent you or just told you about. Anyway, thank you very much for all of you coming, and I hope to see you again September 21st. Thank you.